Hello again. I'm Steve Murphy, a trust and estates attorney with McGuire Woods LLP, and this is Legacy Planning Once Removed, my podcast on property, legacy, taxes, family, and everything else on my mind. This episode is about flexibility. This is about ways to build flexibility into an estate plan. When we talk about trusts on this podcast, we talk about three elements of a trust. Number one, access. Who can have access to or use of the trust assets and property? Number two, control. Who can control those assets through things like investment decisions and decisions about whether and when to make distributions? And number three, flexibility. Who, if anyone, has the ability to change those terms, such as to change the access and to change the control of the trust? I like to focus on those three decisions because they're very broad, what I call strategic decisions. You, the client, make those decisions. Then based on what you want to see, we can build an estate plan structure to accomplish those. And in fact, sometimes that estate plan doesn't involve a trust at all. So this episode is about the third of those aspects of a trust. It's about flexibility. I often work with clients who have an existing trust and they want to modify it. There can be any number of reasons to modify a trust. We've talked about those a little bit on this podcast. But generally, you need to modify a trust because the trust is no longer serving the purposes the settlor intended, or is no longer serving the beneficiaries in the way the settlor intended. Maybe it's a change of the law, or a change of tax law. Maybe it's a change of a beneficiary's circumstances. Maybe it's a positive development, where a beneficiary is very responsible and is now able to take control over the trust. Or maybe it's more of a negative development. We hate to think about it, but a beneficiary could develop issues with substance abuse or addiction, or a beneficiary might be disabled or have special needs. So in those cases, we modify a trust in a way that complies with the law and doesn't trigger unintended consequences, like creditor issues or tax issues. We're especially careful about gift tax issues and issues of the generation skipping transfer tax or GST tax, which I've talked about in other episodes. We don't want to modify a trust in any way that would trigger those kinds of taxes. We want the client to be aware of any risks that might be involved in those kinds of modifications. So yes, we talk about how to modify those types of existing irrevocable trusts. But let's take that a step further. Let's think about the planning process. In the planning process, we can build in flexibility from the beginning. So in that case, if the trust does need to be modified in the future, we have a mechanism to do that. And one way to build in that flexibility is by giving someone a power to change the terms of the trust. This power is called a power of appointment. It's an odd term, the power of appointment. Sounds very legalistic, but essentially you're giving a person, usually a beneficiary, the power to distribute or appoint the trust assets. And there are lots of reasons we use powers of appointment. They're very common. There are different kinds of powers of appointment that can be used for tax purposes and asset protection purposes. So you might see resources online that talk about a general power of appointment. That's especially helpful to address GST tax, which again, I talk about in other episodes. Or you might see references to a limited or special power of appointment. Well, let's leave aside some of those technical issues and just think about how the power of appointment works and how it can be used, and then importantly, some pitfalls to be concerned about. So here's an example of how this power might work. Husband passes away, and at his death, he sets up a trust for the benefit of his wife. Just as a side, as you know from this podcast, I tend to use the male as the example of the person passing away, just because males statistically have a lower life expectancy. But the structure could just as easily work with a female donor or decedent. So under the terms of this trust, they say that upon the wife's death, the assets are divided into further trusts for the husband's children. This structure might work very well, but think about all that could change between the death of the husband and the death of the wife. One of the children could win the lottery and maybe doesn't need the funds at all. Or one of the children could be very responsible and there doesn't seem to be a need for a trust for that child. The child could receive his or her share outright. Or one of the children could have some of those issues, like issues with substance abuse. But if the trust terms say that at the wife's death, the funds go into trusts for the children, then there's really no choice. The funds have to go in that way. Yes, there might be ways to get creative and do some planning after the wife's death, but those are complicated and clunky. So what are ways we can build in flexibility into the husband's estate plan in case circumstances change? Well, one way would be to give the wife that power of appointment. The trust could say that if the wife does nothing, then at her death, the trust assets are divided, as we said before, into trusts for his children. But the trust agreement could also say that if the wife wants, then through her own estate plan, she can distribute or appoint the assets. So this would allow her to reapportion the assets among the children, or this would allow her to terminate a child's trust, so that child's share goes to the child outright. Or it would allow her to insert additional provisions into a child's trust to deal with things like substance abuse. So you can see that this power of appointment can be a really handy power to have. So what's the problem? Or rather, what are some potential pitfalls? Well, importantly, the wife in our hypothetical will have this power, but the power is only governed by those specific terms. As an example, if she can appoint the assets to anyone, then at her death, she could direct the assets away from her children to charities or even to her new spouse if she remarries. Or she could pass all the assets to one particular child who's her favorite, even if we don't think the husband would have wanted it that way. So with a power of appointment, it's really important to think through the kinds of flexibility the power holder will have. And this power can be tailored and modified to the client's wishes. So some common ways to limit a power of appointment could be you could give the person the power to appoint to the donor's descendants only, to keep the assets in that bloodline. Or you could give them the power to appoint assets to the spouses of descendants, but maybe only for limited purposes, maybe just for that spouse's lifetime. You could allow them to appoint some or all the funds to charities. You could enable them to change the shares for descendants, the fractions for those descendants. So you can see there's any number of ways that we could tailor this power of appointment. On this podcast, we talk about the concept of rules and standards, and that's very important in trust law. There's another episode devoted to rules and standards. I think you can see that this power of appointment is a very rule-based concept. The exercise is valid if the holder exercises the power of appointment in a way that's consistent with the specific rules and procedures in that power of appointment. But the problem we're confronting here is that the client might find that this gives the holder of the power too much flexibility. This is because the holder of that power has no duty, no fiduciary duty to exercise or not exercise the power in ways that the creator would have intended. There's a case from 2015 from Pennsylvania that I like to bring up with my clients and in my seminars. That's the case of Estate versus Zucker. The full citation is in the show notes. It's an interesting case. In that case, Carl died, survived by his wife, Seema. Carl also had 3 children, Scott, Karen, and Wendy. Upon his death, Carl's estate plan created a trust for Seema. And that trust provided that upon Seema's death, she had the power to appoint the assets, and I'm going to quote, to or for any one or more of my issue. And she also could appoint an income interest to a child's spouse. So it seemed like Carl was thoughtful here. He wanted to make sure that at Seema's death, the assets stayed within his descendants, although he did provide a potential of a limited amount that could go to a child's spouse. And then if Seema didn't exercise that power, the funds went to his children in equal shares. But in this case, Seema did exercise that power, but she exercised it in favor of Scott and Karen. That is, she excluded Wendy. Well, I could imagine Wendy was upset about this. Her brother, Scott, was trustee, and he did something interesting. He proactively went to court to confirm that this exercise of the power of appointment was valid. By the way, we often find ourselves in that position. If the trustee needs guidance or there's some tricky issue, we sometimes ask the court to step in and answer the question and give us some guidance and certainty. Wendy responded to the petition, and she argued that the exercise was not valid. She alleged that Seema sort of overstepped. She thought that her exercise was done, and here is a quote from the case, quote, in bad faith, based on hate and malice toward Wendy, contrary to Carl's intent to benefit his issue equally, absent a good faith reason to the contrary, and the duty imposed on Seema to act in good faith when exercising a testamentary power imposed by Pennsylvania law. So you can see what Wendy's arguing here. She's saying that yes, Seema had that power of appointment, but she had to exercise it in good faith. She had to have good reason to exercise that. She has a duty to follow Carl's wishes. The court summarized that Wendy argued that essentially the holder of a power of appointment must owe some kind of duty to the creator of the power. But the court concluded that the holder of the power has no such duty of good faith. The court looked at case law and concluded that the only requirement for the exercise is that it complies with the rules. And in this case, the exercise did comply with the rules. It kept the assets within Carl's descendants. So the court found it was valid and Wendy was excluded. And think about how important that reasoning is. The court found that Seema didn't even have a duty of good faith. She could exercise the power for any reason or no reason. By the way, the court and the parties called this power in the case, they called this power an exclusionary power of appointment. That's kind of a harsh term. Sometimes when I use language like that in my law school class, my students all stare back at me with these big eyes like, yikes, that's harsh. And yeah, maybe that is a harsh way to think about it. This is an exclusionary power. This is the power to exclude some of that class of individuals, some of those descendants. But that's also accurate. That's what Seema could have done, and that's what she did do. So what's the takeaway from all this and from this Zucker case? On the one hand, flexibility is good. We often set up long-term trusts for asset protection, asset management, tax efficiency, and other reasons. And especially with those long-term trusts, circumstances can and do change. On the other hand, consider how that flexibility might be exercised and who has that power. And be careful when drafting that power of appointment. So in these episodes, we'd like to close with just some questions or some thought exercises. So how about this? In your own estate plan, consider this issue of flexibility. Do you like the idea? Or would you prefer to say that your wishes and your plan govern? If you do like flexibility, then maybe consider these 3 ways to address it. First, if you have a power of appointment, choose the right power holder. Just be mindful of who is going to have that flexibility. Second, choose the right rules for that power of appointment. If you're concerned about an outcome like the case of Zucker, then maybe insert some additional restrictions, like requiring that each child still receive a fractional share of the whole. Third, consider other ways to build in flexibility into the estate plan, maybe based more on a standard-based approach that would require an exercise in good faith or subject to other duties. As an example, you could build in flexibility by naming a third party called a trust protector. But that trust protector would have to act in good faith or based on other guidelines you provide. And well, trust protectors will have to be the subject of another episode. I'll make a note of that. And as always, as you're thinking about your estate plan, come back to these central strategic decisions about access, control, and flexibility. And while we're at it, also about rules and standards. And as always, this has been Legacy Planning Once Removed, my podcast on thoughtful estate planning. Thanks for listening.